right, Rhenan, 2 minutes now to interpolate Chrissy.
Good evening, Mrs. Speaker. Pardon me if I may sound rude, okay? Decisions are based on fact and law, correct?
Yes.
Yes. Now, Mrs. Speaker, we abide by the principle that what the law does not include, it excludes, correct?
Okay, yes, I do agree with you.
This principle applies in construing the Constitution and other laws, does it not?
Yes.
Now, emotions, as you always, very evident in your speeches, are not included in the constitutional provision, correct?
We are not just basing on emotions, Mr. Speaker. If you listen to this speech, we are...
Allow me to continue.
Okay.
Neither is a public sentiment included in the provision, correct?
We are not basing our argument on public sentiment, Mr. Speaker.
Therefore, we should not judge actually the validity with the decision
No, I don't
based.
agree with you.
Now, let me continue with my questions. The integrity of the Supreme Court is defined by how it upholds the rule of law, is it not?
Of course.
Yes. It's not defined by citing the public clamor, is it not?
Of course
yes,
not.
Yes. It should not stand with its decision despite adverse publicity.
Yes,
is
of course, I do agree with you.
Now, you agree with me that the Supreme Court should not be swayed by the present public sentiment.
Yes, of course.
No. Now, therefore, both parties agree that the test of integrity, therefore, lies on how the Supreme Court upholds the rule of law, which it had correctly done since we are
But the
actually a
upholding
government
of
of
the
men.
rule of law should...
Government of laws and not
But
government.
the internal rules of the Supreme Court should not should not be more...
Come on.
No, the Constitution should prevail over the internal rules of the Supreme Court. That's what I'm trying to say.
No more questions.
All right, Rhenan, 4 minutes now to rebut Chrissy and advance your argument.
Greetings, everyone. At the outset, we from the negative side submit that the act of the Supreme Court is practicable because it is merely reinforcing its powers within the bounds prescribed by the Constitution. Particularly, this recall resolution is within the powers as enshrined under Article 8, Section 5 of the Constitution, which gives the Supreme Court the power to promulgate its rules in the enforcement and protection of constitutional rights, pleadings, practice, and procedure, which includes the power to suspend its rules in order to facilitate in the proper administration of justice. Now, what is just or fair is determined based on whether the constitutional and statutory rights of the parties are safeguarded, such as the right to due process. It has been consistently proven by the negative side that the right to due process was violated by the fact that it was the second division and not the special third division that decided on the merits of the case. Yes, Your Honor.
Mr. Speaker, is this situation any different from instances when the compositions of divisions change because of vacancies and new appointments?
It is actually the same, Your Honor, and the internal rules provide that these are actually it will be made a special division and can actually be subject to the review of the court of the Supreme Court and back. If I may move on, Your Honor. Further, the Supreme Court cannot be gainsaid to have flip-flop in its ruling when it allowed its members of its second division to rule on the second motion for reconsideration. We submit that the Supreme Court made a pardonable lapse. I say pardonable because of inevitable circumstances. There was retirement of justices and the fact that 200 to 250 items are deliberated on during the regular session of the division. Indeed, we empathize with the plea of the FASAP members because the parties are entitled to speedy disposition of case. 13 years is no joke. But what is more practicable? To have this case decided by a division without authority, or to have it been settled once and for all by the Supreme Court and bank with authority. Of course, the latter is definitely more sound, for it will eliminate all the clouds as to its validity. Verily, court decisions should never be compromised to cite the public sentiments, for what we have is a Supreme Court that upholds the rule of law. One that is consistent with the principle that we are government of laws and not a government of men. Moreover, to address the fear of the FASAP of a subsequent reversal of the case, this is purely speculative. But nonetheless, if we are to evaluate, it still appears to be founded because the Supreme Court, in its earlier decisions, had already ruled that there was actually an illegal retrenchment. Ladies and gentlemen, the Supreme Court is not so infallible that will never commit a deviation from its internal rules. Procedural lapses are not impossible to happen, such as in this FASAP case. But It cannot just be simply ignored because it will certainly affect proceedings in future cases that might be placed in the same predicament. The better rule then is to correct these lapses now to serve as a guide for future litigants and the court. Who else will correct this error? Remember that it is only the Supreme Court which has the power and duty to rectify these lapses. To exaggerate it, even God in heaven cannot interfere to rightfully change it. That's all, thank you.
Okay, Chrissy, 2 minutes now to cross-examine Rhenan.
Good evening.
You allegedly, you said that it was assigned in the wrong division, am I correct?
Yes.
Okay, so you said that there was a technicality,
It's
right?
not technicality,
Okay,
it's a procedure.
it's a wrong division, okay. Did you know that Justice Inaris Santiago was the ponente of the decision in the case in 2008?
Yes.
Yes, and are you aware the decision was rendered in favor of FASAP?
Yes.
Yes. Are you also aware that PAL filed a motion for reconsideration?
Pardon, Mr. Speaker?
Are you also aware that PAL filed a motion for reconsideration
Yes.
after rendering the decision?
Yes.
Are you also aware that upon the motion of PAL, the third division held an oral argument on PAL's motion for reconsideration?
Yes.
Okay, yes. But still, the third division denied the reconsideration.
Yes.
Yes. After the first MR was denied by the third division, Justice Santiago retired, am I correct?
He actually inhibited and
No, Justice Santiago.
Retired.
She retired. Okay, and PAL filed a second motion for reconsideration, right, Mr. Speaker?
Yes, but it was filed into the
Okay.
division.
Okay. It is the Supreme Court's rule. Are you aware of AM number 99-8-09?
Yes, that is the
Okay.
internal rules, right?
No, it is the rule on resolving motions for reconsideration.
Yes.
Okay. Are you aware that paragraph 3 of that rule mandates that when the ponente of the decision retires, the case handled by her shall be raffled to the members of the division who rendered the decision? Am I correct?
It was actually the wrong division that...
No. We're okay. Anyway, was it not the fact that following Justice Santiago's retirement, FASAP versus PAL was raffled to Justice Velasco, a member of the third division as well?
Yes.
Are you aware that he inhibited himself from the case?
Yes.
And that because of this, the case was re-raffled to Justice Brion, also a member of the third division, correct?
Yes.
So PAL's second motion for reconsideration had to be acted by Justice Brion. Yes. However, Justice Brion was subsequently assigned to the second division. Am I correct?
Yes.
Yes, this is where the error allegedly took place. But are you aware that according to Section 9 of the internal rules of the Supreme Court, when a justice is reassigned to another division, all his cases go with him?
No.
And that's under Section 9. And then you can say, there is no
That's all the
technicality
time we have,
with the second division.
That's
He
wrong.
should
Okay, Chrissy.
second motion for reconsideration.
All right, may now invite both sides to cross the house as our judges tally the scores. Square off. The CVC law debates will return after these messages.